Did you take anything at all out of the home? And if so, what items did you take?
Yes, we took our bedroom set, living room set. Well, it's my understanding from what we have. It was our bed, kitchen table, chairs.
And those things you had moved by a mover?
No, my wife, my son, and my daughter moved those things themselves.
Couple of things. There are golf clubs. There are photographs of golf clubs. I cannot imagine that something this small was left behind. And if it was left behind, I can't imagine that somebody, the dumpster people, someone didn't move it. Because there were things here of value that would normally not be tossed into a dumpster, like the golf clubs. So unless my colleagues have another question, we're going to excuse the three of you while we deliberate in this matter. Thank you.
This courtroom is now in recess.
All right, so we have two semi-credible teams going here, a little fudging here and there, but the truth is, from what they've both said, he owes rent, she never gave him an itemized list, and she has $3,000 of his. So if we find that he owes 1 month's rent, which I believe he does, then I would be comfortable with letting her hold the $3,000 that she has, and he would basically just owe her $900.
What do we think about the property that she discarded? She admits to throwing these items away. If they had an agreement until the 10th and he was hospitalized and she knew that, then she shouldn't have thrown the things away.
They cleaned out the inside of the house, basically, according to him, and also according to the photographs. And I can't believe a golfer would have said, and she took
No,
my
but they
Callaway
went back.
clubs.
They went back on the 10th when they were supposed to go back and the items were gone.
Except that she's never admitted to taking the golf clubs or certain items.
I think what she admits to throwing out, the drum equipment at a minimum, would offset the $900, but he gave us a list.
Here's the way I'm analyzing it. The plaintiff did not give him an itemized list, and the purpose of that is to give him an opportunity to contest the damage allegations. And since he was deprived of that, she's not entitled to keep the $3,000. And he had until the 10th to remove property, and they threw his property out. Whatever was in there.
But he's not countersuing for anything.
But
that's
it's
correct.
an offset.
But we're talking about using the $3,000 as an offset to the rent that he owes. I agree that he owes the rent.
So basically, we're trying to decide whether or not we should offset any balance that's due and owing.
The $900.
Okay, got it.
Should we deduct from that a value for the property that they discarded?
I could do that. They're both admitting that there were things that were taken, and $900 is not much in this day and age. So I would be happy to dismiss her complaint if that's where we're going with this.
I have no problem.
Okay, I'm good with that as well.
That.
Excellent. We've seen a bit here of what happens when things are not in writing. And then we have people in a contentious position, which makes it very difficult to discern the accuracy of what's being said. But what we do know and what's very clear is as follows. You maintained $3,000 of the defendant's money as a security deposit. You did not comply with both the law and the lease in failing to give notice within 21 days of any damages or any reasons why you would be withholding his money. We also believe, I think you admitted it, that you owed 1 month's rent. So that brought us to the crossroad, which was there's a $900 difference in that. You've also, sir, established that there were items that were in your home that were taken prematurely or precipitously before the date you were given, which would have been the end of business or midnight on the 10th of January. And both of you ladies have admitted to having somebody go to the home with a dumpster, and I'm sure that you took out a significant number of items. And so we, in evaluating that testimony, decided that the property that you wrongfully withheld was in value about $900. So what does that mean to both of you? Well, it means that you've established your position, sir, and it means to you, ma'am, that the $3,900 that you're asking for, you are not entitled to, and so therefore your case, ma'am, is dismissed.